Unit 3, transfer of property. What do you mean by property? Property means transfer of ownership. Now, contract of sale talks about two types of properties, general property and special property. But contract of sale deals with what type of property? General property, that is transfer of ownership. Though transfer of possession is also needed, but more important is what? Ownership, transfer of ownership, correct? Why should we know the time of transfer of ownership? Is because of 4 reasons. First is risk follows ownership. Second is action against third parties. Third is suit for price. And last is effect of insolvency. I have purchased the TV and I am going in auto. Auto meets with an accident. TV also kharab ho gaya. That risk will be borne by the seller or buyer? By the buyer. Why buyer? Because ownership has passed to him. So risk always follows ownership. But can we separate risk and ownership? Yes, by an agreement, risk and ownership can be separated, correct? If the TV is lost, who can file an FIR? Only the owner can file, correct? Buyer can file, right? So, suit against third parties can be taken only by a person who is the owner, right? If agar ownership is not transferred to the buyer and seller ke factory se hi the goods are lost, who will file it? Seller. So, whoever is the owner can file or take an action against third parties. Who is filing a suit on whom for the price? The seller only is filing. And when can a seller file a suit? Only if the ownership has passed to him. If ownership is not passed, normally can he file a suit? He cannot. And last one, effect of insolvency. If ownership has been transferred to the buyer and buyer becomes insolvent, then the official assignee of buyer can claim the goods. Otherwise, he cannot claim the goods. Correct? So, why should we know the time of passing of ownership? Is for these 4 reasons. Once again, what are they? Risk follows ownership, action against third parties, suit for price, and effect of insolvency. Passing of property, is this important? Yes, because the risk follows ownership. Yahi reason hai na? Why did we underline this? I don't remember. Legal rights and liabilities of sellers and buyers. So, passing of property constitutes the most important element. Passing of property implies property is passed to the buyer, means risk in the goods also is transferred to the buyer and not the seller, even if the goods are in seller's possession. So, who is going to bear the risk depends only and only on transfer of property, on ownership, does not depend on possession, correct? We saw some cases over here when the ownership passes. And how many cases did we see? 4 cases. First case is where the goods are specific goods. Second case is where the goods are unascertained goods. Third case where the goods are sold on approval. And fourth case where the seller has reserved a right of disposal. So, we need to know how and when the ownership passes in these cases. So, coming back to the first case, when will the ownership pass in case of specific or ascertained goods? Whenever the parties intend it to pass. If we do not know, whenever the parties intend it to pass. How do you know what is the intention? T, C and C, which is what? The terms of conduct and circumstances. If we do not know the intention, then these 3 rules will apply, correct? First rule is what? Specific goods which are in a deliverable state. Second rule is specific goods to be put in a deliverable state. And last one, specific goods which are to be weighed or measured, correct? I go on Saturday and I choose a television and I tell him today is Saturday, so I'm not going to take this, but this TV I want, I will come on Monday and take it. When will ownership pass? Is when we decide to pass, correct? He tells me, you pay the price only, then I will give the TV to you. So, when will ownership pass? Only after payment of price, correct? But if we do not know the intention, then the first rule will apply. Specific goods which are in a deliverable state, ownership passes at the time of making the contract. So, ownership passes on Saturday or Monday? On Saturday, correct? Second situation, which are to be put in a deliverable state. To be put hai matlab something has to be done so that it's in a deliverable state. So, example was wooden table, teak wood table example. So I choose a TV. It is a specific goods. It's ready there with the seller. He says, yes, I'll give this to you. But just because, it's open for so long, ek final polish pending hai. I will polish that tomorrow and I will give you a call. So when will ownership pass? After the polish is done and buyer gets a notice of it. Correct? And last case, where it is to be weighed or measured. For example, buying vegetables or buying gold. So where you are buying gold and you ask for 1 tola gold, 1 tola is given to you. It is weighed and measured as well. For what reason is it weighed or measured? To determine the price, and purity is checked as well, correct? So once that is done and buyer gets a notice of it, ownership passes to the buyer. Clear? So specific goods agar hai, when does the ownership pass? Is when the parties intended to pass. Intention, how will you know? Based on TCC. If you don't know the TCC, then talk about these 3 rules, correct? Then these 3 rules will apply. Clear? Next one. If they are unascertained goods, ownership cannot pass until and unless the goods are. 2 things. First one, until and unless the goods are in a deliverable state and they are unconditionally appropriated to the contract. What do you mean by appropriation? It means selection of the goods with the intention of using them for the performance of this contract, correct? So until and unless they are ascertained is what we would read. How is this ascertainment done? Is by appropriation. Appropriation means what? Selection of goods for using it for this contract. 50 kgs of rice is kept in a sack. I ask for 1 kg. Out of that, where he takes out 1 kg. Why is he taking out 1 kg? So that it can be used in this contract. So what he has done is basically appropriated. Was it there? Were the goods in a deliverable state? Yes. So ownership will pass only and only when they are in a deliverable state and they are unconditionally appropriated. This appropriation that is done by the seller should be unconditional. Means it should be without any conditions. Correct? Where the seller is reserving a right of disposal, means it is a conditional appropriation. Ownership cannot pass, correct? But it should be unconditional, means the seller should not reserve a right of disposal. Clear? Where the seller sends the goods, say by railways, RR is made in the name of the buyer. There is he reserving or not reserving a right of disposal? Not reserving a right of disposal. Where RR is made in the name of the seller, then it means deemed to have reserved the right of disposal. Clear? When this appropriation is done, there are certain essentials of appropriation. We read it in this form. Hai na? So first is what? The goods have to be unascertained. They should conform with the description and quality as per the contract. Next one, they have to be in a deliverable state. Next one, appropriation should be unconditional. When appropriation is done, it should be done by the seller with the assent of the buyer or by the buyer with the assent of the seller. This assent should be express or implied, and this can be given before or after appropriation. Okay, think of the example where we are purchasing coconut from a kirana store. Either we take it ourselves and go to the counter, or we first enter into contract, then pick up the coconut. Either he takes it for us or we take it for ourselves with his consent. Think of this example. All these essentials will be simple. Clear? Simple. Any doubts here? Okay, this second case is also over. The third case that we have, wherever goods are sent on approval, also called as on sale or return basis. So I have taken 3 necklaces from my friend and I am going to gift it to my mom. Whatever necklace my mom likes, correct? So over here, I bring the 3 necklaces. First, I call up. My mom says she likes the first emerald one. So I call him and I tell, this emerald necklace, I am going to keep it. So ownership passes to me only for the emerald necklace, not for the other 2 necklaces, correct? अगर समझो other 2 necklaces का कुछ तो भी natural calamity आता है and loss हुआ है, that will be borne by the seller. Even though possession is with me, does not matter, है ना? Ownership is what is important. Only emerald wala will be borne by me, correct? Or else I bring these 3 necklaces. Guests are there at home. Too much panchayati they have. They see what it is, they like it, and I tell them, you want to take it? Okay, take 5 lakh rupees each. I sell these necklaces to them. I have done something here to show that I have adopted the transaction. So ownership for all the 3 necklaces has passed to me when I am selling these necklaces to the guest, correct? And third case is what? He tells me, marriage season hai abhi, you select anything and you return whatever you don't want within 3 days time. If I retain beyond 3 days, ownership has passed for all the 3 necklaces, correct? So where a time is specified, it should be returned within the specified time. If not returned, ownership is going to pass for all the 3 necklaces, correct? Okay, changing the wordings again. If a time is specified, it should be retained. It should be returned, है ना? मतलब it should not be retained beyond the specified time. And if no time is specified, it should be not be retained beyond a reasonable time. Clear? Once again, just see the wordings. So in these 3 cases, ownership passes. First is where the buyer signifies his approval or acceptance to the seller. Second case is where he does any act adopting the transaction. And third is where he retains the goods beyond a specified time, and if no time has been specified, then beyond a reasonable time, correct? Sometimes it can so happen that even though goods are sold on sale or return basis, they are sold for cash or return basis, correct? So in this case, ownership will pass only after cash is paid, correct? Until then, ownership does not pass to the buyer. Clear? We had discussed some bigger questions also over here. Yaad hai na thoda sa? Yes or no? Guest ko ownership has passed or no? I told you? No? Okay. Yes. Okay, good. Okay, last case over here was what? Where the seller has reserved a right of disposal. Oh, sorry, I told you I'll give that in the exam. I told you the example orally, I think, but I didn't make you write that because I told you I'll give it in the exam, है ना? नहीं? Yes. Last time भी बोले आया नहीं. Last time नहीं आया. Last आया. Yes. Something I don't remember. कुछ भी नहीं आया. इस बार आएगा. Morning आया था. Special damages I had given. Hey, revise. What is this? Reservation for right of disposal. Means what? Means what? Seller is reserving a right of disposal. Means the seller is putting some conditions. When will ownership pass? Only after those conditions are fulfilled. Either this reservation of right of disposal can be expressed. Matlab seller is telling you pay the price. Only then ownership will pass to you. Or it can also be implied. In these 2 cases, we are considering the seller has deemed to have reserved the right of disposal. First is the RR is made in whose name? Seller's name. He has reserved the right of disposal. Or else it is made in the name of the buyer. But along with RR, there is one bill of exchange. RR to be valid only if bill of exchange is accepted. So in such a case, seller has deemed to have reserved the right of disposal. Correct? और क्या है? कुछ भी नहीं है. बस. Next topic over here is transfer of title by non-owner. So sale by non-owner. Only that person can give what he himself has got. If he has got a good title, he can give a good title. If his title is defective, the buyer also is going to get a defective title. If he has got no title, buyer will get no title. If he has a bad title, again buyer will have a bad title. Bad title, no title, defective title. तीनों के लिए we use one word which is defective title. Okay, clear? Latin maxim we have over here. What's that? Nemo that quad. Non-habit means nobody can give what he himself has not got. Then normal introduction may be by hearted few sentences. First is what? Seller cannot transfer a better title to the buyer for the goods than what he himself has. If the seller is not the owner, then the buyer will not become the owner. The title of the buyer is going to be the same as title of the seller, and this memo that quite non-habit, correct? But we have got exceptions. Means in all these cases, even though a person is not the owner, the buyer is getting a valid title. First, just tell the headings to me. First is title by estoppel, sale by mercantile agent, then sale by one of the several joint owners, then by seller in possession under voidable contract, then sale by seller in possession after sale, then sale by possession, over which seller has got rights and unpaid seller and 3 more other acts. So transfer, title by estoppel. What's the example? The owner is in US, his friend is in Hyderabad, machine is in Hyderabad. He tells the buyer who is also in Hyderabad, friend se baat kar le and take this machine. They decide the price and friend gives the machine to the buyer. Friend, is he the owner of the machine? No, but is the buyer going to get a valid title? Yes. Why? Because by estoppel, the owner made the buyer believe that the friend had the authority to sell. Correct? Second case is what? Sale by mercantile agent. Sale of Activa. I told the mechanic to sell the Activa for 50,000 and I'm on vacation, phone is off. Everybody, whoever approaches him, they are ready to pay only 20,000, 15,000. One person is willing to pay 35,000. He tries to call me, but I am not reachable. But what he does, ye bhi buyer chala jayega. He sells it off. Did he have the authority to sell for 35? No. But is the buyer going to get a valid title? Yes. Why? Because 3 conditions are satisfied. First is, the mechanic is in possession of the Activa. Second, it is done in ordinary course of business. And last one, buyer has acted in good faith and for consideration. So he was not aware that the mechanic did not have the authority to sell for 35,000. He did it. He entered into this transaction in good faith. He was not aware. That's why we are giving him a valid title. Clear? Third one is what? Sale by one of the several joint owners. So what was this? Laptop. So ABC are partners. They agreed that it is a joint property. Laptop. That laptop is going to be with Mr. A only. Without asking B and C, A sells this laptop. Will the buyer get a valid title? Yes, because while it was in A's possession, it had come to A's possession with the permission of other joint owners. So sale can be done without their permission. It will be valid. Clear? Next one is what? Sale by seller in possession under a voidable contract. TBZ and Princess example. Correct? So Princess over here, by fraud, she poses to be a princess and she takes the necklace. She gives a check. She sells it to the moneylender. Will moneylender get a valid title? Yes, he will, because in a voidable contract, third party gets a valid title. If it's a void agreement, third party does not get a valid title. Clear? Next one is sale by seller in possession after sale. So Saturday ke din when I have chosen that TV, we don't know the intention. So ownership has passed to the buyer on Saturday itself. On Sunday, sales tax officer goes to that shop. He asks for that TV. Can the seller sell that TV? Yes. Will the sales tax officer get the valid title? Yes, he will, because sales tax officer has bought it in good faith, not having a notice that the TV was already sold to somebody else. Correct? Next one, sale by buyer in possession, over which seller has got some rights. So over here we apply this when ownership has not yet passed to the buyer. So seller says, if you want to purchase this phone, you pay 30,000 now and 40,000 later. Ownership will pass to you only after payment of 40,000. Buyer pays 30,000 and he sells this phone to somebody else. Will the other buyer get a valid title? Yes, he will, because it was in the buyer's possession and the other purchaser, the buyer, took it in good faith. Yes or no? Hai na, yaad aaya? This was what we had written. Correct? Next one is what? Sale by an unpaid seller. So now you know, unpaid seller, does he have got a right to resell? Yes, he can resell the goods in those 4 situations. Hai na? And last one is what? Sale under other provision. So 3 people over here we are talking about. Official, assignee, finder of the goods and pawnee. Correct? Performance of a contract. In a contract of sale, how many parties are there? 2 parties. Who are they? Only 2. Buyer and the seller. Buyer is the person who buys or agrees to buy, and seller is the person who sells or agrees to sell. What are seller's obligation? Transfer ownership and give delivery of the goods. Correct? What are obligations of the buyer? To pay the price and accept the goods, right? In this unit, we are going to see these two things, which are what? Delivery of goods and payment of price. Can anything else be specified in a contract? Okay. Normally, delivery of goods and payment of price are to be performed concurrently. But can delivery and payment be done at different times? Yes, as per the contract. Correct? So I had given you an example online. Amazon से तुम कुछ order कर रहे हो. You are paying right now. Delivery is done after 4 days. Is that okay? Yes. If you are ordering COD, cash on delivery, then you are going to pay cash whenever it is delivered. Correct? So delivery and payment are concurrent conditions. Delivery means what? Voluntary transfer of possession. From whom to whom? From one person to another. Correct? Since we are talking about sale, it will be from the seller to the buyer. But just say from one person to another. And delivery can happen in these three ways. First way is what? Actual delivery. Second is symbolic delivery. And third, constructive delivery. What is the meaning of actual delivery? Where the goods are physically handed from seller to buyer. What do you mean by symbolic delivery? Means of obtaining possession is transferred. Correct? So if I sell my phone, I will give my phone to the buyer. What delivery is this? Actual delivery. Where I sell my car, what am I going to give? Only keys of the car. What delivery is this? Symbolic delivery. Correct? And can there be any other type of delivery where goods are not moving from one person to other? Yes, and that is what? Constructive delivery, also called as delivery by atonement or delivery by acknowledgement. Correct? In this type of delivery, there is a change of possession without the change in the actual or visible custody. मतलब जहाँ पर goods है, they are going to be there only, but the possession has changed. Which will happen in these three cases? First is what? Seller is in possession who agrees to hold them on behalf of the buyer. I have purchased a new car. I go to take the delivery. He says, if you want me to do the RTO formalities, keep it for 5 more days over here. So I agree and I keep it. I have actually taken the delivery, correct? But for RTO right now again, वापस लेकर देने की जरूरत नहीं है. Goods are with him only, but it will be treated as if I have taken the delivery, है ना? Now earlier he was holding the goods. Now he is agreeing to hold the goods, but on behalf of the buyer, correct? Second situation is what? Buyer is in possession and seller agrees to the buyer's holding as the owner. I have given my old car to my friend for use. He calls and he says, I call him and tell, give the car back, I want to sell it. My friend says, I am only ready to purchase it. I tell him, okay, 5 lakhs is the price. He gives the money to me. Should he give the car back to me and again I give back to him? No. Can it be there with him only? Yes. But has delivery happened here? Yes. There is a change of possession without change of custody. Earlier he was holding like a bailee. Right now he is holding as if he is the owner. Correct? And third point is what? Where the third party acknowledges that he is holding on behalf of them. Correct? So what was the example? Cold storage example. So the 1000 kgs potatoes are there only. Earlier register में seller का नाम लिखा है. Now cold storage keeper strikes off seller's name and writes the buyer's name. Have the goods moved? No. But is delivery done? Yes, it is. Clear? Now so many rules of delivery we have. First is mode of delivery. Next is delivery and payment can be concurrent conditions. Next one, effect of part delivery which is in progress for the purpose of transfer of property is treated as if it is effect of whole. But where the intention is to separate the part from the whole, ownership is going to pass only for the first part. Correct? A purchaser of cement, he orders 100 cement bags. The seller sends all the 100 bags in a truck. Unloading चल रहा है. सुबह unloading start हुआ है. In the evening it is ending. All the time when the delivery is in process, unloading is in progress, it is treated as if delivery is done. Correct? But if suppose the buyer wanted only 5 bags, उसका neighbor ordered for 10 bags, so इसके 5, उसके 10, उसके 50, all of these are sent in a single truck. ownership will be transferred only for the 5 bags. Even though in the truck there are 100 bags, ownership will be transferred only for 5 bags, correct? So the first point applies only when the delivery is in progress, correct? Next one is what? Whose duty it is? Buyer's duty it is to ask the seller to deliver the goods, correct? Can the seller deliver even without buyer asking? Yes, but if the buyer does not ask and the seller does not supply, the buyer cannot hold the seller responsible for breach. Hai? So duty to give is the seller's, but duty to apply is the buyer's. Clear? Next one is what? Place of delivery, whatever is specified in the contract. अगर कुछ specified नहीं है तो no, place, I am talking about place. Where the goods are when you are entering into an agreement to sell, that will be the place of delivery. If we talk about time, we are talking about two types of times. One is the hour of the day and one is the duration. So if we talk about the duration, within a reasonable time, and if we talk about hour of the day, then business hours on a working day. 1000 kgs of tons of coal supplier takes at 2 AM in the night into the factory. Udhar hi hai uska ghar. Is he bound to come and take the delivery? No, because it is not reasonable hour. It is not reasonable hour, correct? Not business hour, hai na? Okay, goods in possession of third party. How will ownership pass or delivery happen? When the third party acknowledges. Cost of delivery unless otherwise agreed. Loading is borne by the seller. Unloading is borne by the buyer. So cost of making delivery is borne by the seller. Cost of obtaining delivery is borne by the buyer. Correct? Next, very, very important, delivery in wrong quantities. We have ordered for how many TVs? 50 TVs, but we have got, first case, 40 TVs. So where we get 40 TVs, what can we do? Get angry, hai na? Reject the goods, or else we'll say, theek hai bhai, itna to rehne de. So we are accepting 40. If we are accepting 40, we have to pay for 40 TVs only. Second situation, excess delivery. What has happened? We have got how many? 70 TVs. What can we do? Either reject entire 70 or else accept entire 70 or else accept only 50, which was as per the contract, correct? Where we have accepted entire 70, we have to pay for entire 70 at what price? At the contract price. So contract price of TV was 20,000. Right now market price is 25,000. How much we have to pay? 20,000 for all the 70 TVs, correct? Then delivery mixed with other goods. So LCD mixed with LED mixed with LCD agar raha, three things we can do. First is reject the whole, accept the whole, or accept only that part. Correct. Installment delivery. Is the seller entitled to give? No. Is the buyer entitled to accept? No. Agar contract hai वैसा installment में करने का, then fine. If not, nobody is bound to accept or to give by installments. Clear? Next is delivery to a carrier. Normally will be treated as if it is delivery to a buyer. So buyer is telling send the goods by rapid transport company. Seller sends by rapid transport company. Risk is with the buyer. Buyer tells rapid transport, but seller sends slow transport. Risk is with the seller. Wherever sea transit is involved, two types of contracts are entered. They are FOB or CIF. In case of FOB contract, what is the seller's obligation? To deliver the goods only? To deliver the goods? Okay, he will be bearing the cost only up to a particular point. And what is his obligation then? To inform the buyer. Goods yahan tak hai, abhi tu insurance lena hai to le, correct? So once the seller informs, the risk is with the buyer whether or not he takes an insurance. In CIF contracts, risk is with the seller, because the cost that the buyer is paying includes the insurance as well. Yes or no? Abhi yaad aaya? Okay. Then deterioration during transit. जो भी normal transit में normal loss हो रहा है, all of that will be borne by whom? Buyer. Even though the seller is agreeing to deliver at his risk, normal loss will still be borne by the buyer himself. Clear? Yes. Now, is acceptance and delivery one and the same? No. What is more than the other? Which one? Acceptance is something more than just delivery. one person goes to Bose showroom, है ना, to see the speakers. He sees those speakers, he really loves it. Salesman had taken his name and number. He goes to office and when he reaches home, he sees, oh, both speakers are here at home. Has delivery of the speaker happened? Yes. Has acceptance also happened? No. When will acceptance happen? In these three cases. First case is where he signifies, intimates to the seller. Second case where he does any act adopting the transaction. And last case where he retains beyond a reasonable time. Why reasonable time? Because no time is fixed, correct? So three similar points similar to sale and approval, right? So where he retains it, ownership has passed to him, है ना? So basically, when he sees the Bose speakers, either he can accept it or he can reject it. If he is accepting it, in these three cases he has accepted it. If he is rejecting it, what is his obligation? He only has to intimate, call and inform him, ये नहीं चाहिए भाई तू ले ले, correct? The risk will be with whom? Is going to be with the seller only. Is the buyer bound to go and return it to the seller? No. What is sufficient? Only if he informs, intimates the seller, correct? In fact, if the seller does not take the goods for a reasonable period of time, what the buyer can do is also charge. What charges? Correct. Higher, not higher charges, custody charges. So he will be like the bailee, correct? As per contract, buyer and seller have entered into a contract. Is buyer bound to accept the goods? Yes. If the buyer doesn't accept the goods, can seller file a suit? Yes. So seller can file a suit for, we have seen this non-acceptance, suit for non-acceptance, correct? So this last part that is there, that is as per contract where the buyer refuses to accept the goods. There is a breach by the buyer. Yes or no? Clear? Simple, right? So when goods are sent to the other person, acceptance, delivery हुआ है but acceptance नहीं हुआ है, he can either accept it or he can reject it. He will accept it in these three cases. If he is rejecting it, he only has to intimate the seller. Simple. Last part over here are the rights of the buyer. So buyer के rights we divided into two. One is general rights and other is specific rights in case of breach of contract. General rights are how many? 5. Specific rights are how many? Also 5. General rights, first one is right to have delivery as per contract. Next is right to reject the goods in wrong quantities. Next one, right to refuse delivery of goods by installments. Next one, receive notice of insurance. And last, right to examine the goods which were not examined before. In case of breach, these are the rights of the buyer. First is suit for non-delivery, suit for specific performance. Next is suit for breach of warranty. Next, repudiation before the due date. And last is suit for interest and price. Clear? Everything we've discussed at some point or the other. Do you need explanation for anything over here right now? This is okay, right? So rights of buyer are against the 5 and 5. What are they? Sorry. General rights and against seller in case of breach. So see and read them once again. Against general rights are how many? 5. What are they? Have delivery as per contract. Then reject the goods in wrong quantities. Refuse delivery by installments. Right to receive notice of insurance and examine the goods which are not examined before. And what are the other 5 rights against the seller? Suit for non-delivery, suit for specific performance, suit for breach of warranty, repudiation before due date, and interest and price. Okay? So unit 5, rights of an unpaid seller. Who is an unpaid seller? That seller to whom the whole of the price has not been paid or a negotiable instrument is given but it is dishonored. Correct? What are the rights of an unpaid seller? He has got right against goods and against the buyer, right? Against the goods we have 3 plus 1 rights. 3 rights in case of ownership being transferred to the buyer, and one in case where ownership is not yet transferred to the buyer, correct? What are those against the goods? 3 plus 1 rights. First is right of lien, next is right of stoppage in transit, and next is right of resale. What is that right which is where ownership is not being transferred? Right of withholding delivery, correct? Which is same as right of lien or right of stoppage in transit, correct? Now first let us talk about right of lien. Lien means what? To retain. So right of lien means what? Right to retain the possession. Why can the seller retain the possession? Until the price is paid, correct? So only one reason ki wajah se seller can retain the goods, that is what? For payment of the price, hai na? This is also called as vendor's lien. Vendor is nothing but a seller, correct? Now 1 lakh ka TV the buyer has, correct, 1 lakh ka TV the buyer has purchased. The seller gives him 1 lakh rupees, but the seller says, I am going to keep this TV over here because last year you took 1 lakh from me. This 1 lakh that you have given right now is towards adjustment for that debt. What he's telling, is it valid? Not valid. Why? Because he cannot exercise lien for adjustment against any other debt. It can be exercised only towards payment for price of that goods, correct? Buyer has purchased 10,000 bags, out of which 7,000 are delivered to the buyer. Now the seller wants to exercise the lien. Can he exercise the lien? Yes, but only on how much? Only on the balance 3,000 bags, correct? Why can't he exercise it on 7,000 bags? Because the possession is lost, correct? Lien matlab kya hai? To retain. Retain karne ke liye pehle the goods have to be with the seller himself. So the minute the possession is lost, the lien is also lost, correct? Where the seller is exercising lien, does it mean he is cancelling the contract? No. Will the contract still remain valid? Yes. And when will it be performed now? After payment of price. Lien can be exercised in how many cases, or are there conditions? Cases. How many cases? 3 cases. First case is if it is a cash sale. Second case, if it is a credit sale but the term of credit has expired. And last is where the buyer becomes insolvent. First case is a cash sale. So cooler, pump manufacturer, pump seller and cooler manufacturer. So where the pump seller says, I am ready to give this to you, but you pay the price first. Is he exercising the lien? Yes. Second case where credit period is allowed. So pump seller says, I am not going to allow credit period, season chal raha hai. But because the cooler manufacturer requests, he says, okay, you come and take the goods right now. I will give you a credit of 5 days. What should the buyer do? Go and take the goods. He doesn't go. He goes on 6th day. Now the seller says, abhi credit period bhi nahi hai. I am not going to give you the goods until and unless you pay the price. So he is exercising lien, correct? Remember this, ye jo credit hai, it is unlike our regular credit. Normally when we take goods on credit, we are taking the goods right now. Price we are going to pay later. So where the buyer has taken the goods, can the seller exercise the lien? No, because possession is not there with the buyer, correct? So this kind of lien is a little different. This kind of credit is a little different, right? And the last case is what? Buyer has become insolvent. So where buyer has become insolvent, seller can exercise the lien. So what do you mean by insolvency over here? Is it the court adjudged insolvency? No, it is just a commercial insolvency. So rumor के जैसा चल रहा है market में that the buyer is not going to pay the price. So can the seller exercise lien? Yes, he can. Correct? और क्या है यहाँ पर? Part delivery is done. Termination of the lien. So seller loses the right to exercise lien in these different cases. All mean one and the same. But anyway, see what are they? First is what? Where the goods are delivered to the carrier. Normally, goods delivered to the carrier is treated as if goods are delivered to the buyer. So where buyer has taken delivery, lien cannot be exercised. Second case, where the buyer has obtained possession, obviously. Third one, where seller has waived the right. He can exercise lien, but he doesn't want to exercise lien. He has waived his right. Then is he exercising lien now? No. Next case, by estoppel. He is making people believe that he is not going to exercise lien. So now he cannot exercise the lien. And last case is what? हाँ बस इतना ही. Only these 4 cases, right? Once again tell me what are these 4 cases. First is where goods are delivered to whom? To a carrier. Second, where buyer is obtaining possession of the goods. Next one, seller has waived his right. And last one, by a stopel, where he makes people believe that he is not going to exercise the lien. है ना? Next right that we have is what? Right of stoppage in transit. So right of stoppage in transit means to regain the possession of the goods. Where are the goods right now? Are they with the seller? No. Are they with the buyer? No. They are in transit. So this right can be exercised only and only if these how many? 5 conditions are satisfied. First condition is that the seller is an unpaid seller. Next one, the seller has parted with the possession of the goods. Now where are the goods? In transit. The buyer has become insolvent and comply with the provisions of this act. So only if these 5 conditions are satisfied, stoppage in transit can be exercised. So seller is in Hyderabad and the goods are sent to Delhi. So goods are going in a truck and this seller in Hyderabad calls the truck fellow and says, "Udhar U-turn le le." Remember this? है ना? So where he is taking a U-turn, what right is the seller exercising? Right of stoppage in transit. Buyer को पता चलता है, buyer calls and asks, "What happened? Why has the truck turned?" He says, "Again, you have become insolvent. That is why I am not sending the goods to you." Buyer says, "No, no, no, this is false. I have lot of money. ये ले तेरा पैसा." Buyer immediately G-pays it to the seller. Now what the seller tells again? Truck fellow, "Wapas U-turn." Now again wapas U-turn and the truck is going to Delhi. Has the contract come to an end? No again. Will it be performed? Yes, but only on payment of the price. Clear? So this is right of stoppage in transit. Duration of transit. Till when will we regard as if the goods are in transit? Till the buyer takes the delivery of the goods, correct? Goods have reached Delhi. They are in Delhi, the carrier's warehouse. Has the transit ended or is it still in transit? Still in transit. So even though they have reached Delhi, transit does not come to an end because buyer has not yet taken delivery, correct? Now these are the cases where we treat the transit to come to an end. So कुछ तो भी अपन याद रखे थे क्या अलग टाइप का? Yes. What was it? Acha, 4 are in line. Okay, first case is what? Where the buyer obtains delivery. Second is what? Hero buyer. What is he doing? Interception. Third case. Courier is acknowledging that now he is holding the goods for buyer. Matlab goods to the carrier is goods to the buyer. Correct? Next case is what? Similar case. Carrier wrongfully refuses to deliver the goods to the buyer. So यहाँ पर गलती किसकी है? Carrier की है, चोर carrier है ना? Yes or no? I've written that. Okay, next one is what? Similar points. Goods are delivered to a carrier which was hired by the buyer. Similar point. Goods delivered to a ship which was chartered by the buyer. And one more, where part delivery has been made. The transit ends for the remaining goods which are yet in the course of transmission. Clear? Once again, in these cases, transit comes to an end. First case is buyer obtains delivery. Second case, interception. Third case, carrier acknowledges. Next case, carrier wrongfully refuses. Next case, carrier hired by the buyer. Last one, ship chartered by the buyer. And one more, in case of part delivery. Correct? Stoppage in transit is effective. What is the meaning over here? What was this? Stoppage in transit affected by taking actual delivery of the goods or by giving a notice. कुछ नहीं था ना यहाँ पर. Okay, redeliver अगर करने का है, those expenses will be borne by the seller. Nothing over here, right? Okay, next one. Lien and stoppage के differences. How many? 5 differences. First difference, meaning. Lien means to retain possession. Stoppage means to regain possession. For excising lien, the possession should be with the seller. For excising stoppage, the seller should have parted with the possession. Correct? Insolvency of the buyer. In case of lien, the buyer may or may not be insolvent. In case of stoppage, he must be insolvent. So can you exercise lien even when buyer is not insolvent? Yes. In how many cases? Two cases, cash sale and credit sale where credit period has been expired. Correct? Because in lien, those 3 points are cases. In stoppage, they are all conditions. So buyer has to be insolvent for exercising stoppage. Right? Next difference is what? Right of stoppage. Filmy difference. Right of stoppage begins when? When right of lien comes to an end. Correct? When does right of lien come to an end? Once the goods are delivered to the buyer. That is what is the next point. Correct? You have to read. Only then you will get it. Clear till here? Yes? Okay. What is this? Effect of subsale or pledge by the buyer. So second buyer, he cannot stand. कुछ तो फालतू है ना ये. What is this? What is the first principle? This is based on the principle that a second buyer cannot stand in a better position than the first buyer. But there are exceptions. In these cases, second buyer is going to get a valid title. What is it? First one, where it is a document to title has been transferred and the other person has paid it, has taken it for good value, है ना? In good faith for value. Correct? Sale and pledge effect is the same. ठीक है. Next one, right of resale. What is the seller doing? Reselling the goods. Ownership has passed to whom? To the buyer. But goods are still with the seller. Can he sell the goods? Yes. In how many cases can he exercise this right? 4 cases. First case where the goods are perishable. So if the goods are perishable, is there any notice to be given? No. Second case, if they are not perishable, compulsory for the seller to give a notice to the buyer. If he gives the notice and he incurs any damages, those damages can be claimed, and if he incurs any profit, he can retain that profit. If he does not give a notice, can he claim damages? No. And if whatever profit he earns, he will have to give it back to the seller, the buyer. Correct? Third case is what? Where the seller has exercised lien or stoppage, then can he sell the goods? Yes. And should he give a notice? Not required. Correct? And last case is what? Where in a contract the seller has expressly reserved the right of sale. मतलब वो पहले ही बोल रहा है, if you don't take the goods, I am going to sell the goods. Over here it means basically he has told it already. So that telling already only is regarded as if notice is given. He can then sell the goods, right? Right of resale can be exercised in how many cases? 4 cases. First case is what? Where the goods are perishable. Second case, where notice is given to the buyer. Third case, where lien or stoppage is exercised. And last case, where it is expressly reserved in this contract of sale. Simple? Okay. Next right that we have are rights of the unpaid seller against whom? Against the buyer personally. So how many rights does seller have? 4 rights. First right is what? Right to sue for the price. So, okay. All the 4 rights. First right is to suit for price. Next one, suit for damages for non-acceptance. Then repudiation before the due date. Suit for interest. So, suit for price. Who is filing suit for price on whom? Seller is filing the suit to receive the price from the buyer. But this suit can be filed only and only if the ownership has passed to the buyer. Correct? Ownership agar passed nahi hai, can the seller file a suit? He cannot. But there is one exception, and that exception is what? In case of mutual and independent promise. So 1st of July, the buyer had to pay the price. Was he getting the car from the seller? No. Was he becoming the owner of the car? No. 15th July ko the seller was going to give the car. So जैसे ही first date आया, buyer has to pay the price. जैसे ही 15th date आया, the seller has to give the car. Even where the buyer does not pay the price, the seller still has to give the car. But what can the seller do? He can file a suit for price. So this is the only exception. Otherwise, normally, if ownership has not yet passed to the buyer, the seller cannot file a suit for price. Clear? Next right is what? Right to sue for damages for non-acceptance. As per contract, buyer ko obligation hai to accept. If he does not accept, seller can file a suit. Clear? Next one is suit for repudiation before due date. So what do you mean by repudiation before due date? Anticipatory breach. So कौन breach कर रहा है here? Buyer. And that's why what options does seller have? 2 options. Either he can cancel and immediately claim damages, or else he can wait till the due date. On the due date, how many things can happen? 3 things. First is super winning impossibility. Second is buyer performs, and third is buyer does not perform. Super winning impossibility raha to damages cannot be claimed. If the buyer performs, then seller is bound to accept, and if he does not perform, then he can claim damages. What is the measure of damages in these cases? Market price minus contract price. Whichever date we are, take the market price of that date. Clear? Then next one is what? Suit for interest. So see, whenever interest becomes due, whenever price becomes due, the buyer has to pay the price. If buyer does not pay the price, the seller can file a suit for price as well as he can file a suit for interest. Correct? Agar specific agreement hai, interest will be charged at 9% per annum. Then what rate will the seller charge it at? 9% per annum. But agar interest ka koi specific agreement nahi hai, then reasonable rate as deemed fit by whom? By the court. Is this clear and simple? Yes. Last part of sale is what? An auction sale. So in auction sale, what is happening? There are many people who are doing what? Who are bidding, and they are called as what? Bidders. Or we do not call all of them buyers. जो एक final person buy करेगा, fall of hammer से जब accept होगा, only that person will be called as a buyer. All the others are bidders. Correct? Normally auction sale में the auctioneer is either the seller himself or he is the seller's agent. Right? Auction sale is always an invitation to offer. So there was an advertisement that auction will be held in Chennai. Person from Delhi goes to Chennai. Auction sale is not held. Can he file a suit on the auctioneer? No. Why? Because it was only an invitation to offer. So what makes an offer in an auction sale? What makes an offer? What is an offer? The bid. The bid that the bidders give is an offer. Is contract formed after the bidder gives a bid? No. Contract will be formed only by fall of the hammer. That is the acceptance. Correct? Auction sale specifically provides once a bid is given, it cannot be taken back. Is this term valid? No, because a bid is only an offer. Can it be taken back? Yes. Until when? Until it is accepted. Correct? So 50,000, 80,000, 90,000 ऐसा bid हो रहा है. 90,001, 90,002, and the auctioneer is about to drop the hammer, and he suddenly says, no, sorry, I want to withdraw my bid. Can he say that? Yes. Even though auction sale specifies you cannot withdraw it, can you still withdraw it? Absolutely, yes, it can be withdrawn. Correct? Whenever goods are sold in auctions, there are some rules that we follow. First one is, where goods are sold in lots, every lot will be treated as if it is a separate contract. Correct? So 1,000 shoes are sold in one lot. Even though they are separate 1,000 shoes, all the 1,000 shoes together will be regarded as a single lot, as a single contract. Correct? Next one is what? When is acceptance done? By fall of the hammer, and until then any bidder can retract, take back his bid. Next one is right of the seller to bid. Can the seller himself bid in an auction? Yes. What will he be called as? A puffer. So seller himself, or he can appoint any other person to bid, he'll be called as a puffer. This type of bidding is called as, not the effect, called as pretended bidding. Why is puffer appointed? So that the prices can be raised. Correct? How many puffers can the seller appoint? Only one. And should he inform that this sale is subject to a puffer? Yes, because if it is not informed, it will be treated as if it is fraud. And at the option of the buyer, it will then be voidable. So, एक puffer appointed है. Seller does not tell that puffer is there. There is one painting that is sold by auction for 5 lakh rupees. But the buyer purchases this. After that, he gets to know कि puffer था. What can he do now? At his option, contract is voidable means what can he do? He can resign the contract, or he can keep it valid, correct? But can he cancel the contract? Absolutely yes. Even after fall of the hammer, can you cancel the contract? Yes, that is the meaning of voidable. After you enter into contract, you can cancel it. Clear? So this type of bidding is called as a pretended bidding. Remember that. Highlight that as well. So it is pretended bidding, means puffer is appointed, है ना? So third point and fourth point, they are similar points. It means exactly the same. So where it is not informed that there is a puffer, it is voidable. Buyer can avoid the contract. Clear? Now these bidders in an auction, they form a group and they enter into a contract or an agreement called as knockout agreement. इसमें ये लोग क्या करने वाले हैं? They are not going to bid beyond a particular price. कोई एक bidder को the auctioneer is going to sell, and once that goods are sold, they are going to sell the goods in the market. They are going to make a profit and they are going to share this profit. This kind of agreement is called as knockout agreement. What is the validity of knockout agreement? It is valid. It is not illegal. But if the intention is to defraud somebody, then it's going to be illegal. But prima facie, the knockout agreements are valid. Clear? So to knock out this knockout agreement, what does our seller do? Auctioneer. He fixes a reserve price. Reserve price or a base price or an upset price is that price below which bids are not going to be accepted. Correct? So reserve price is fixed by whom? By the auctioneer. And knockout agreement is entered into by whom? By the bidders. Another type of illegal activity can happen in an auction sale called as damping. So damping is an unlawful act where the bidders or the purchasers are taken away from the place of auction. How? Either by a device or by unnecessarily pointing out defects in the goods. Clear? You remember car का example? ये कार में भूत है. Or else what? क्या करना है तुमको? You see, correct? So they are taken away by some other device, or else they are unnecessary defects are pointed in the goods. What is damping, legal or illegal? It is illegal, है ना? Now because of this fear, there are many people or companies who opt for e-auctions, है ना? E-auctions are what? Electronic auctions, right? Do you have to go to the place? No. So damping होने का chance बहुत कम है ना? Okay, anyway, that aside. So this was damping. What else? Can taxes be included in a contract of sale? Yes, where goods are sold for a price, for example, 10,000 plus taxes. The date of performance of the contract is after 1 year, and next year the tax is 10%. Then they'll have to pay, buyer will have to pay 10% tax. If the tax reduces to 5%, they'll have to pay 5%. Sometimes contract price is decided, which is inclusive of tax. In that case, will the buyer have to pay anything else? No, that whatever price is decided, that only will be there. Clear? Simple? Yes? Sure?